Items from daily list, promotion bail application, item number 1.
May I please? This is application number 439, shown arrest. He was arrested on 23/4/2024 and 36 behind the days behind the bar. And my FIR is on page 11. Type copy. Married. What is FIR laws on 1 year back? I am arrested shown as in that case. Allegation against me, I am receiver of the stolen property. And my not forwarding is on second forwarding. Nothing recovery from me. So arrest on suspicious ground for investigation purpose only. My detention may not be necessary for further period.
Mr. Bosio,
Lordship.
Nothing has been recovered from me. Second.
pardon?
Nothing has been recovered from me.
You have been shown arrested in this case on 23rd for 24.
36 days.
30?
36 days today. Completed
36 days.
behind the bar.
Yes, Bosio?
City may be produced, Lordship.
Okay. CD.
Nothing has been recovered. My second production of page 21. Page 21. There is no recovery from me. So
Okay, heard me, sir.
Page 21.
What is your name?
A Khan.
Learned counsel for the accused, and also heard Mr. A. Bosio, learned additional PP for the state respondent. This application under section 439 services prepared by accused Kasif,
Yes.
who has been languishing in jail as in connection with course of PS case number 239 of 2022 under section 411, 413, 34 APC. No, 379. Edit section 411, 413, 34 APC. It's to be noted here that above noted case has been registered on the basis of an FIR lost by one Hirokviti Dasgora of NR Electrical on 8/8/2022. The sense of allegation made in the FIR dated so and so is that some unknown persons have committed theft of one battery bank of 600 AH capacity of 6 cells and comprising of 6 cells and terminal stripe 23 pieces from ATC site within bracket golden ID global ID 553173 site name Gorsok near ISBT. Mr. Khan, learned counsel for the accused, submits that the accused was found arrested here in this case on 23rd/4/2024, and earlier he was arrested in connection with
Mosulpur PS case number 33. 24.
in connection with
Page paragraph 12. Masulpur PS case number 33/24.
Mosulpur PS case number 33 of 2024. And further, learned counsel for the accused submits that nothing has been recovered from the possession of the accused And he is behind the bar for last 36 days, and therefore it is contended to allow this petition. Whereas Mr. A. Bosho learned additional PP submits that at this stage the CD may be called for. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record, and also perused the documents placed on record. Then it appears that the accused was arrested on accused has been shown arrested here in this case on 23rd 4 2024, and for last 36 days he has been languishing in jail. He was arrested earlier in connection with Mosalpur case number so and so. And further it appears from the forwarding report, page number
Case number 21.
from the forwarding report dated 26/4/2024 that nothing has been recovered from his possession. Having considered above and also especially the length of detention, this court is of the view that further custodial detention may not be required in the interest of investigation, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup and the accused be enlarged on the
Item number 2 for bail hearing.
Prove. Apart from license. Yes,
Item 2.
Made clear. 439 application lodged. Petitioner is in custody for 14/6/2022 since 14/6/22.
so this is second application.
Second application.
So what is the ground?
Here Lordship may only see
So
page
firstly,
32,
you were behind the bar for how many days?
715 days.
715 days.
1 year, 11 month, 15 days.
Yes, what is the first order?
First order your Lordship will find page 38.
And what is the ground for filing this second application?
In page 41, your Lordship will find that there was some observation to expedite the trial.
Hmm.
Page 41, Lordship may only see. And this order was passed on 9/1/2023. And after more than 1 year, 6 months, about 1 year, 6 months, Lordship, this trial is still at appearance stage, Lordship. And if your Lordship can proceed to pay-
Madam, why the case is pending in the appearance stage?
not evidence, Lordship, charges are not framed yet.
No,
Still
no,
in
that's why I'm asking her. Why?
appearance, because page 32, Lordship, for a moment, if your Lordship see, page 32.
Yes.
Page 32, paragraph 60, Lordship may only see that the supplier of Sis Iman heroin was Munna Bhai. Due to non-appearance of Munna Bhai, alias Domini supplier, the role of Munna Bhai Domini is under investigation. If any evidence found in respect of him, the same will immediately be submitted before the Honorable Court. Then prayer number 1, your Lordship will find that the complainant humbly prays that continuation of further investigation may be allowed in instant case against accused and other suspect persons. So their prayer was the further investigation, probably, subject to what my learned friend clarifies, Lordship. Whether they have subsequently filed any application that they will not continue their further investigation or not.
No, how many accused have been searched?
3,
3.
2, I'm sorry, two persons searched.
All of them are appearing before the trial court.
Only one person, I am behind bar. Other person against them, they have paid that further investigation against that person is needed. It is their prayer, Lordship.
But can we grant you bail on this ground of delay alone?
Delay, Lordship, that I have already submitted one compilation, Lordship.
Hmm.
That Ravi Prakash says, Lordship, if there is undue delay, that will dilute the rigors of section 37. So that delay probably, in my humble understanding, Lordship, that Lordship depend on the each and every case, Lordship. That we cannot mechanically say this is the delay. But in my case, what I have placed before your Lordship, that since long back I was in custody, my bail application was rejected on 23 January 2023. And on January 23, there was a direction to expedite the trial. And even after that, so we are on 24 and 24 or 5 Lordship, that about 1 year, 5 months has passed, but still the case is at appearance stage.
Mm.
So this delay, that there is no chance of early hearing, and this delay will cause prejudice to me. So in that view of the matter, that section 37 can be done.
Yes, but there is a judgment of 3 judgments of Supreme Court where it is stated that only delay on the ground of delay in serious cases, bail cannot be granted to the accused person.
No, that Mohit Agarwal's case,
The
that
judgments you have relied upon are of 2 judgments.
yes, but that in that case, Lordship, there was not that is not the case of only delay, Lordship. Here, Lordship, that Article 21 is brought into. Here, in that case, sorry, subject to correction, Lordship, that was in investigation stage, Lordship.
Which one?
That Mohit Agarwal's case.
No, I am not referring to Mohit Agarwal. Another decision is there. This. Kalyan Sarkar versus Papu Jadhav or Rajesh Ranjan versus Papu Jadhav. Another decision is there.
That
Rajesh Ranjan, yes.
regarding delay, Lordship.
Delay,
Delay in trial.
yes.
That I have not gone through, Lordship.
You go through that judgment. We will list the matter tomorrow or day after tomorrow.
Day after tomorrow.
Day after tomorrow. Okay. As agreed by learned advocates of both sides, the rest shall list the matter day after tomorrow. So as to enable Mr. Ahmed, learned counsel for the accused, to produce one judgment of Honorable Supreme Court in the case of Rajesh Ranjan Sarkar versus Kalyan Sarkar versus Rajesh Ranjan. Citation to them. Okay.
Obliged.
You have next.
From Kohima bench. Item for judgment.
All the 3 review petitions stands dismissed. The contempt petitions are released. And the writ petition is also released. As the writ petition has not reached the stage of hearing. Recessal list the matter, list the writ petition for here for filing for passing necessary orders separately.
Number 3.
Lordship, the second bail application in connection with Lordship LIPS case number 33/2021, and the petitioner is attracted under section 21C of NDPS Act, Lordship, recovery of opium paste, Lordship.
So what is the ground for filing this second application?
The second application was filed, Lordship, on the strength of last order, Lordship. My lord has
Where
filed
is the order?
page 58, Lordship, paragraph 13.
Page 50.
58, Lordship, paragraph 13, Lordship. In view of aforesaid facts and circumstances, it's annexure 11, Lordship.
That is page number 55.
It starts from 55, Lordship. Relevant page is 58.
Yes.
Paragraph 13, in view of aforesaid facts and circumstances, this
Mm.
court is of the view that this is not a fit case for granting bail to the accused, and accordingly the same stands dismissed. However, the learned court below is directed to conduct day-to-day trial and to complete the trial as early as practicable without being influenced by any of the observations made herein above, Lordship.
Mm.
So this order was passed on 15/3, Lordship, and
Mm.
accordingly we have filed the next bail application, Lordship. The basic contention that the delayed trial, Lordship.
Mm.
Out of the 10 witnesses, Lordship, 6 have been examined, Lordship, material witnesses,
How
including
many witnesses cited in the charge sheet?
10, Lordship,
10.
10, Lordship.
Out of 10, how many witnesses have been
6
examined?
have been examined, Lordship, including IO, Lordship. IO is the material witness, Lordship. All the material witnesses have been examined, Lordship. Lordship, at this stage, I will not press for delayed trial, Lordship. The long detention, Lordship. He has been behind the bar for 2 years, 10 months, and 20 days till date, Lordship.
That's all right. If you are not harping on delay,
Delay party is there, Lordship, otherwise. And he has no any criminal past antecedents, Lordship. And he's not likely to commit any offense, Lordship.
no, in view of the judgment of Supreme Court in Mohit Agarwala, can we consider your pair? Because earlier also we have referred to that decision.
Yes, Lordship, paragraph,
Hmm.
paragraph 12, Lordship.
And this delay ground also I have already stated in the earlier bail application. No, in the previous application
Yes, Lordship.
regarding the three judge bench decision in Kalyan Sarkar versus Rajesh Ranjan.
Yes, Lord.
You go through the judgment, you find it out.
Yes,
Can we consider that ground period of detention
yes.
and also the delay? So then Thursday?
Thursday.
Item number 7,
Obliged.
item number 7,
None appears for the accused on call. Registration is the matter after 1 week.
7,
My lord, senior counsel, my lord, YS Mahan is on lake at another court, my lord, court number 70.
Okay, day after tomorrow then.
item number 4,
May I please your lordship. In this case, your lordship, either he was interim your lordship, accordingly he was appeared and his statement was recorded by the IOE lordship.
When?
8/4/2024, your lordship. Interim was granted by this honorable court, your lordship.
So Mr. Sharma, say here charge sheet is submitted.
My lord,
Charge sheet number 37 of 2024
yes, my lord,
against who is
against my
accused?
lord, all accused, my lord,
All the accused.
all the accused.
Then what are the sections?
Under section, my lord, 4th, 54 and 380 of IPC, my lord.
Kindly,
So the applicant had appeared before the IO?
already appeared, your
Appeared.
That information is not with me.
appeared, your lordship. As per party concern, your lordship. Lordship, my humble prayer is this, Lordship,
And,
kindly,
uh,
maybe.
Okay,
absolute, your
okay,
Lordship.
okay. Not absolute, you go and appear before the trial court, apply for regular bail.
Lordship,
Heard Mr.
Yes, Islam.
Learned counsel for the applicant and also heard Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Talukbari PS case number 70 of 2024 under section 454 T80 IPC. This application under section 438 service is prepared by applicant Amirud Zaman for grant of PRS case. The above noted case has been registered on the basis of one FIR lost by one. Manjur Ali on 17/2/2024. The sense of allegation made in the FIR dated so and so is that on 17/2/2024 at about 7 a.m. in the morning, two boys, namely Imtaz Ali and Kalu, entered into his house to commit theft. And then he raised a hue and cry, and the local public apprehended one of the thief and recovered a ceiling fan from him, from his possession. Learned counsel for the applicant submits that the applicant was granted the privilege of years bail by order dated 8/4/2024, and pursuant to the said order, the applicant had appeared before the IO and cooperating with the investigating agents. And therefore, a contention is being made to make the interim order dated so and so absolute in the same terms and conditions. On the other hand, Mr. B. Sharma, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet, being search sheet number 37 of 2024, dated 26/1/2024 under section 454 T80 IPC. Whereas in view of the submission of learned advocates of both the parties, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail, and in the event of filing on or before
12 June.
and to apply for regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law.
Oblige you.
Item number 5,
The number 5, my lord, we have not received the case diary.
Mr. B. Sharma, learned additional PP, submits that he has not received the case diary. Accordingly, it is provided that Mr. Sharma shall produce the case diary before this court on
on 20 June.
20 June. Short, no, copy. Short date, first week.
On 5th June,
No. Short date,
on 3rd June.
3rd June. Okay.
Oblige, Lordship.
Item number 8,
Yes. Was your CD is available also?
CD is available, Lordship.
Yes.
And relevant part, Lordship, I have flag marked.
Is there any
There is some-
material against him?
Here, Lordship, some statement from the co-accused,
Hmm.
that is there. Otherwise, Lordship, as per the statement made here, the another case accused me already under some bail.
One of the co-accused have already been granted bail.
Yeah.
Clear bail.
Yes, Lordship, that was annexed in the petition.
15, page number 15 onwards.
So except the statement of co-accused, is there any
No, Lordship.
evidence?
No, Lordship, I didn't
No.
find. Only that statement was only.
Heard Ms. P. Boda, learned counsel for the applicant, and also heard Mr. Boishaw, learned additional PP for the state respondent. Paragraph number 20. Ms. Bora, learned counsel for the applicant, submits that the name of the applicant find no mention in the FIR, but he has been apprehending arrest as because he is being searched by police, and that one of the co-accused, namely Sanjay Khandik, has already been granted the privilege of peerless bail by this court by order dated 17/5/2024 in AB number 11777 of 2024. And that the applicant is ready to cooperate with the investigating agency and therefore is contented to allow the petition. On the other hand, Mr. Boishaw, learned additional PP, has produced the case before this court and submits that the IO has collected some materials in support of the allegation made in the FIR. And therefore, Mr. Boishaw has opposed the petition, where I having heard the submission of learned advocates about the parties. I have carefully gone through the petition and the documents placed on record and also perused the case with the assistance of Mr. Boishaw, learned additional PP. It appears that one of the co-accused, namely Sanjay Khandik, has already been granted the privilege of peerless bail by order dated 17/5/2024 in AB number 11777/2024. And further, it appears that the stolen articles have already been recovered and seized by police. And as such, custodial interrogation of the applicants, in the interest of investigation, which appears to be progressed significantly, seems to be not warranted in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant, in connection with Sipsagar TS case number 36 of 2024 under section so and so, shall be released on peerless bail on his executing a bond of rupees 50,000 with 1 0 liable to the satisfaction of the arresting authority. The above privileges are subject to the following three conditions. Plus condition, he shall not leave the jurisdiction of CJM Sipsagar without prior permission. Case there will be later.
Item number 6, order matter for hearing.
So we are hearing appeal order IA,
Lordship had heard the matter,
entire matter.
entire matter
okay.
for disposal. Last occasion, I was asked to apprise the honorable court regarding point of alibi.
Point of
Alibi.
alibi, yes.
Yes, my lord, that in.
Yes, I have referred to perhaps one case law, do not Pandey.
Yet, that last occasion I have stated. So lordship directed me to the reasoning part where point of alibi has been discussed by the honorable, by the learned court below, my lord. In this point, my lord, appellant has stated as per PW 12 and 13 that on the night of occurrence, accused number 2 was out of the house and PW 12, my lord.
PW 12.
12, my lord. The accused Arup Bora was relevant line I am reading, my lord. 12:39.
Yes.
The relevant
Purnakanta Barua. PW 11 Purnakanta Barua.
Pranjal Datta, my lord.
PW 11.
12 and 13.
Yes.
I'm referring 12 and 13.
Yes, Pranjal Datta.
Yes. First paragraph, last line, my lord.
Hmm.
The accused Arup Bora was with me on relevant night. The accused Arup Bora was my worker. They were busy in some Bhavna, some Bhavna pandal, my lord. So in cross-examination, it is stated, police interrogated me. I have stated before the police while asking me that Dhananjay accused Arup and I at dinner and went to the Bhavna, but Ratan left to his house and refused to go with us. So next one is PW 13, my lord. Here it is stated, first para.
Yes.
On 9/2/2020, accused Arup Bora was with us by doing pandal work on the occasion of Bhavna. We returned back home after completion of our work on the next morning. So Lordship asked me to find it from the judgment part where what is the reasoning on this prosecution witnesses stand, my lord. I found para 8 of the judgment, my lord, internal page number 9. While making the comparison with other witnesses, my lord, first part is not relevant.
Paragraph number.
Paragraph 8 starts, relevant para starts from A, page 9, and relevant one is page 10, second para, my lord. In cross, I'm reading, my lord. In cross, thus she stated that victim girl herself, it is about para PW 7. While in cross stated that the victim girl herself came back to her parents' house and she was not assaulted by anybody. PW 12, Sri Panjal Datta stated in his evidence that he knows the informant as well as the accused persons. He heard that on the relevant night of occurrence, one of the unknown person came out of their house. He cannot say from whom he heard about the occurrence. The family members of the informant and accused persons had good terms and maintained their relationships. The accused Arup Bora was with him on the relevant night. The accused Arup Bora was his worker. PW 13, Sri Dhananjay Bora stated that he knows the informant and the accused persons. He knows that there was a good relation between the accused family and the victim. The victim was brought to the house of the accused by eloping her. On 9/2/2020, accused Arup Bora was with them by doing pandal work on the occasion of Bhavna. They returned back home after completion of their work on next morning. After that, they came to know that there was some occurrence took place, but he doesn't know exactly. Having assessed carefully, I find nagging a doubt on the veracity of the testimonies adduced by PW4 Rumi Datta, own wife of accused number 2, accused A2, PW6 Srimati Mai Bora, mother of the accused persons, PW7 Srimati Bobby Soikia, sister of the accused person, and PW13 Sri Dhananjay Bora, co-worker with the accused A2, of being family members and interested persons. So this is the only part of reasoning, my lord, where he stated, the learned court below has stated, discarded their statement on the basis of interested person, my lord, only.
But Is it the correct proposition of law that evidence of interested persons should be
No,
discarded?
If they throws appropriate light to the prosecution story, that has to be considered, my lord.
Mm.
But only because of interested person, their version cannot be discarded in toto, my lord.
Mm.
But there is no such other reasoning I find in the judgment itself, my lord.
In respect of this plea.
12 and 13, my lord. Specifically, I am yes. 12 and 13 has pleaded, has deposed regarding alibi, my lord. On the point of alibi. Others are no doubt, they are relatives of the person concerned. And
Question is, the plea of alibi will succeed only when the accused can show that at the relevant time of occurrence, it is impossible to remain in two places.
yes, my lord. On that count, lordship had asked me, as PW 12 and 13 is a prosecution witness,
Mm.
and they have deposed like that,
Mm.
that he was with them.
Mm.
So what is the defense regarding here, my lord? What judgment, what the learned court below, what is the reasoning of on the point of alibi? So entire judgment, while I am going through, my lord, I find only this person as interested, interested person, my lord.
Mm.
Independent finding, I don't find, my lord. Because in other part of the judgment, my lord, there is no such
So,
reason.
in his 313 statement, he took the plea of alibi.
I have to check up my phone.
Go ahead, Honor.
313 and say, Mudakas. In the charge sheet also, my learned friend, day before, earlier occasion stated that he was, that A2 was far away from 5-6 kilometers
Mm.
from the place of occurrence, my lord.
Mm.
313.
So whether he had taken such a plea before the trial court,
Pardon, my lord.
whether the appellant had taken the plea of alibi before the trial court.
No, I don't find.
So for the first time,
First time it is raised in appeal, my lord.
but is it permissible under the law?
This was,
I think not.
your lordship, this was, it is said throughout the evidence that he was far away from the place. From the place of occurrence, your lordship. From the
But
beginning,
if the two prosecution witnesses stated that he was at a different place at the relevant point of time,
Yes,
and having not been declared them hostile,
yes.
what would
Last
the-
occasion, I pleaded that, my lord, that they were not declared as hostile.
Mm.
On that point, my lordship asked me to find out from the judgment what is the reasoning behind this, if it is not hostile. But I don't find that they are not declared, I find that they are not declared as hostile witness.
Mm.
And say at the same time, point of alibi, plea of alibi was also not taken in the trial, my lord.
Mm.
Though it is a prosecution witness,
Mm.
but point of alibi was not taken.
your lordship, they were also taken to, for 164 statement, this PW 12 and PW 13.
Mm.
And this person was also supported by the IO during his cross examination. Your lordship. The investigating officer has deposed before the land court that these persons were far away from the place of occurrence. Your lordship. This person, the present accused person.
In 313 statement, my lord, point of alibi was not taken. In explanation part, nothing. In respect of Arup Bara, A2.
So what is your submission then?
Look, my lord, it is raised for the first time, my lord. That is not
No, that's okay,
permissible.
but if we examine the entire case of the prosecution in the light of the evidence of PW 12 and 13,
13.
what would be the consequence according to you?
As that pleading was, plea was not taken as alibi, my lord. Neither the 313 or nor the other witnesses, my lord. So that punishment in respect of the A2 is, that is sustainable, my lord.
Sustainable.
Because for the first time in appeal, that plea was taken. Earlier, it was not taken.
No, maybe he, by virtue of his being an accused,
My lord,
he
he
is
may
not
not be able to adduce evidence
he
on
has
his
a
part.
constitutional right to remain silent throughout the trial. But if PW 12 and 13 has not supported the prosecution case and
They
they
ought
have
to
not
have
been
been-
declared hostile,
Yes, my lord, that
And-
was not that.
then can we arrive at a conclusion that the prosecution case has been proved beyond all reasonable doubt?
May not be,
May not.
may not be.
Yes, Mr. Sharma?
My lord, though, my lord, one thing, my lord, not discussing, my lord, judgment, my lord.
Hmm.
But one, my lord, came to my mind, my lord.
Hmm.
That, my lord, the occurrence took place on, my lord, 12 PM, my lord.
Hmm.
And my lord, from the, my lord, if it, PW2 statement, my lord,
Hmm.
is clear. So after committed that crime offense, my lord, the accused number 2, my lord, fled from the house, fled from the room, and my lord, from the house.
PW2 is the victim.
Yes, my lord, from the victim statement, my lord.
Hmm.
PW2, my lord.
Hmm.
Yes, my lord. It tell you the 164. And my lord, after that, my lord, after 12, my lord, he may be at the place of my lord, that pendle, my lord, that place of Bhavna, my lord. But that
the
is not
thing
discussing the, my lord,
this
judgment.
PW 12 and 13 stated that all along he was with them.
Yes,
You have not declared them hostile.
yes, my lord.
Then,
One thing I
Your-
would like to add, my
yeah,
lord,
yes.
lordship's permission, that time was not stated in the
Yes.
12 and 13 evidences, my lord. At what time, though they say that entire period, entire night, they were busy in raising the pandal, but
Mm.
no such time, up to which time, they just only stated till morning, one stated till morning.
Throughout the night, proceed, throughout the night.
Occurrence
the
took
next
place
day.
on my lord 12 PM.
Midnight, my lord,
Yeah.
12.
Thereafter, and my lord, from the statement, it is clear that he fled from the house, fled from the room as well as from the house. After committing that offense, my lord.
No, except the PW2, whether any witness have seen him.
No, no.
No witnesses said, even the.
Except to my lord.
Even the person who has took her to the paternal house, there too she has not stated to them that such incident took place there. No, even the mother of the victim, never she stated such incident took place in the house of the accused person. She was silent throughout it.
Hmm. Okay,
Well,
we reserve the judgment. Heard Mr. R. Chetty, learned counsel for the applicant, and Mr. B. Sharma, learned additional PT for the state respondent number 1, and Ms. M. Verma, learned legal aid counsel for the respondent number 2. Argument concluded, order reserved, judgment reserved.
Item number 9 by VC mode.
All right.
Item number 9 by VC mode.
Problem.
Yes, my lord.
Yes, I do. But this,
So,
I got the,
you have received the translated
yes,
copy?
yes, yesterday. we got-
Yesterday we have received Lordship.
Yesterday I've got the,
Have you been able to go through the same?
not thoroughly to do.
Not thoroughly.
Today, my lord, now it is already. Any hearing them, my lord?
Any hearing date?
Today also.
Heard Mr. K.K. Parasar, learned counsel for the appellant, and Mr.
And I sent for respondent number 1. On behalf of
You
Mr.
are
Ardo.
on behalf of Ardube.
Dubey.
Mr. N.I. Hussain, learned counsel, appearing on behalf of Mr. Ardube, learned counsel for the respondent number 1, and Ms. D. Borpuzari, learned legal aid counsel for the respondent number 3. Mr. Parasar, learned counsel for the appellant, submits that he has received the typed copies of the evidence of PW1, PW2, PW5, PW6, PW7, PW8, and PW1 yesterday only, and as such, he pressed for granting him some more time to, so as to enable him to go through the same. Here is accordingly allowed. Rest is the matter on. When?
During third week of June.
No,
Not
from,
third week, it will be motion day then.
next Thursday possible.
6.
Thursday? কি বলো? Oh. এটা first week of June. No, heavy no, fourth of June. No, it is 2011 matter. So,
On 11, on
no,
4 June.
4 June,
Oh, my,
4 June.
Obliged Lordship. One point I have missed.
Yes.
That, page 15 of. I'm sorry, my lord. That page 15 of the internal judgment, the timing part is observed by the honorable court, learned court below. It's
You know,
it is going, it's too important. Internal judgment, page 15, that paragraph, it is start from page,
page 7. Inter-
page 15, my lord. It's a long paragraph, my lord.
Para number 7.
Para number 11, it is start from page 12, but
Okay.
observation part, relevant part is page 15, my lord. 1, 2, 3, 4,
Timing
5,
part.
6, 7, 8, 9, 10, 11, 12 line, my lord, from the top.
Okay.
May I read, my lord?
Mm.
Further, the evidence of PW 12, Sri Pranjal Datto and PW 13 of Dhananjay Bora cannot be relied wholly as they fail specify the time of working with the accused A2.
Mm.
Merely stating whole night working them does not prove the fact of alibi.
Acha. Okay.
Recapitulating it, I find that the prosecution could bring home the facts beyond all reasonable doubt and accused A1 and victim prosecutors has love affairs out of which both of them married and subsequently accepted by both of the families. This part is
No,
not relevant.
the appellant is the brother-in-law of the victim.
Victim.
Version.
A1 is the husband, my lord.
Allegation is under section 4 earlier,
Yes,
and he is convicted under section
10.
10. Is it possible?
No, my lord. That also reasoning part, I try to find, my lord.
Mm.
Last occasion, lordship had asked me
Mm.
whether it's that follows section 9 provisions are followed or not.
Mm.
He has in paragraph 13, learned court below has mentioned all that clauses of section 9, my lord.
Mm.
But so far as reasoning part,
Mm.
last 4 line from the bottom, it stated without any reasoning in the Attorney General for India versus Satish on 18 November 2021. Relevant page is 20, my lord.
Mm.
Stressed upon the definition start with the words whoever with sexual